Um, Good morning, good evening, everybody. We're really excited to have you today on a USIBC webinar with Khaitan and Company. We're trying a new format here, and I can tell you that I'm really excited. For those of you who know me, you can tell me that I'm excited because I both shaved, I'm wearing a collared shirt, and I have a jacket. And so the idea here is that we're going to go through a number of topics that often aren't covered during our priority issues. And we are bringing in a team of legal experts in a nightly news format. We're really excited. When this is all said and done, I'd love to hear your thoughts and comments about this type of format. Should we continue it in digital topics we can incorporate into this, or perhaps leveraging the overall format in other areas? With that, I'm going to hand it over to Paku Khan from Khaitan and Company to moderate this. And thank you for joining, and hope you find it interesting and insightful.
Thank you so much, ladies and gentlemen. I'm Paku Khan with Khaitan and Co. And as Jay said, we are trying a unique format here. We're going to make it like a newscast, probably without the weather and the sports updates and any fake news. But we're going to try to bring you the highlights of what we think you as digital economy participants need to know about what's recently happening in India. And because we have such a variety of topics and a variety of speakers from my firm, Khaitan and Co., and if we can go to the next slide, we did want to present it in such a way to hold your interest from start to finish. We're going to have about 40 minutes total. So all of our speakers are going to have about 30 minutes, taking about 3-4 minutes on each topic. And that'll take us to the 30-minute mark, and then we'll leave 10 minutes for Q&A at the end. So please feel free to, I think, Jay, type their questions into the chat, and then we'll get to those questions at the end. So let me very quickly introduce my partners, and this is pretty much the order that they're going to be speaking in. We're going to have Bijal Ajinkya from Mumbai, who's one of India's foremost tax partners. Adhish Nargalkar from Mumbai as well, who's going to walk us through some intellectual property developments in India. Sharad Abhyankar, who's a corporate governance and corporate partner in Mumbai, talking about some changes to CSR. And then Supratim and Anushka Sharda and Atish will try to walk us through some developments that are of general interest. Tanu Banerjee will walk us through some changes to social intermediary guidelines from a consumer protection standpoint. And then finally, my partner in Delhi, Indruj Rai, will talk about some potential issues with tax associated with some the intermediary guidelines that have been recently presented. So let me now move to the agenda, which is what we've just talked about. We'll cover it in this order: software royalty tax, which Bijal will talk about; the patent rule changes, which Adhish will talk about; CSR, which Sharad will talk about; some general news items, and then Tanu talking about the changes on influencer guidelines from a consumer protection standpoint, and then finally Indruj on tax issues. So Bijal, let me ask you to start it off. We've just had a fairly significant judicial case come down about software royalty tax that I think has implications not just for software producers, but users as well. Turning it over to you.
Good morning to everyone, and a very warm welcome to all of you. So earlier this month, the Supreme Court of India, which is the apex court in India, delivered a landmark verdict, which comes as a silver lining for the software industry. This ruling is relevant for foreign companies supplying software to Indian end users or distributors, especially the US, since it would be the largest exporter of software to India. It is also relevant for players in the SaaS industry catering to the Indian market. So what was the issue in a nutshell? Essentially, the issue was whether income arising to foreign companies from the sale of software was business income or royalty income. Income is said to be business income when it arises from the sale of goods, while income is said to be royalty when it arises from the license of some intangible intellectual property rights like copyright, patent, trademark, etc. Business income is not taxable in India unless the foreign company has a business presence in India, while royalty income is taxable in India on a gross basis and does not require a presence at all. The tax authorities were seeking to tax the income earned by foreign companies through sale of software to Indian residents as a royalty income. For example, where an Indian end user purchased software directly from a US-based company, it was alleged that the US-based company earned royalty income and not business income. By taking this stand, the tax authorities could recover a tax at the rate of 10%, which was previously 20%, on such transactions. Also, the payer was under an obligation to withhold the taxes. The tax authorities' argument rested on the premise that income earned by software suppliers essentially constitute income from parting with their copyright in the software and hence was royalty income. On the other hand, the taxpayers who were foreign companies contended that the sale of software was nothing but a sale of copyrighted article and did not involve parting with any copyright in the software. This issue has been litigated in India for more than 2 decades, and conflicting judgments on this issue by the lower courts only compounded the problem. In the middle of the 2-decade debacle, the tax authorities were so tired of defeat that the Indian tax law was amended in the year 2012 with retroactive effect to bring software payments taxable, and the only savior was the shelter under the tax treaty. This issue of taxability reached the Supreme Court, where various companies such as IBM, HP, to name a few, were in appeal. Almost 100 companies were literally heard together. The Supreme Court, by a common judgment, disposed of the appeals on this issue and ruled in favor of the foreign companies, holding that the income earned from the sale of software did not constitute royalty income, but it was in the nature of business income and hence not taxable in India. So that leaves us with a million-dollar question. Are these payments not taxable in India at all post this ruling? Sadly, the answer is likely to be a no in many cases. With the digital tax introduced last year, whereby online sale of goods and services is taxable at 2%, however, of course, this 2% tax is way better than the 10% tax and of course is levied only on a digital supply. Hence, this ruling definitely accords certainty on tax treatment for foreign companies supplying software to India. Thank you. Paku, over to you.
Thanks very much, Bijal. And now we'll move to my Mumbai-based intellectual property partner, Adish Nirgalkar, to talk about some recent changes to India's patent rules. Adish, over to you.
Thank you. Good morning, good evening to everyone. In October and November last year, the patent rules were amended. The key highlights of the amended rules are, firstly, the fees applicable to small entities for filing and prosecution of Indian patent applications have been reduced substantially and made at par with those of natural persons or startups. Even before the amendment, the fees applicable to a small entity were 50% less than the fees which were applicable to a large entity. With this amendment, the fees applicable to a small entity have significantly reduced, that is almost 1/4 when compared to a large entity. With this reduction, hopefully, it will encourage small entities to innovate and also seek patent protections for their innovations. The second key amendment is the statement of commercial working. Now, earlier, one would have to file the statement of working within 3 months from the start of the following year, that is by 31st of March for the calendar year, that is 1st Jan to 31st of December. With this amendment, the statement of commercial working of the patented invention will have to be filed by every patentee and every licensee individually for every financial year, that is 1st April to 31st of March, within 6 months from the start of the following financial year, that is by the 30th of September of the following year. Therefore, the timelines have been relaxed and it is easier for the companies to plan this statement of working. Further, the Form 27, that is the prescribed form to file the statement regarding the commercial working of the patented invention, has also been amended. Now, in one form, we can submit all the related patents with the information that is going into the form. Earlier, for each and every of the patent, even if it is relating to the same patented invention, had to be filed separately, whereas now the following information, that is, in case the patented invention has been worked, then the approximate revenue, value, the quantum of it which has been accrued in India through manufacturing and or importing, all these can be submitted into one form. Similarly, in case the patented invention has not been worked, then the reasons for not working of the inventions or the steps being taken for working of the patented invention needs to be mentioned in the form. Further, the rules in relation to the priority document and the English translations for the Indian national phase applications have been amended. It has become easier because a priority from a patent application can be claimed using a DAS code, which is the Digital Access Service. These were the key amendments in the patent amendment rules. Over to you, Paco.
Thank you, Adhish. And now we're going to switch gears a bit and go to corporate social responsibility, or as it's affectionately referred to in India as CSR. So our partner Sharad Abhyankar, who's based in Mumbai, is going to walk us through, I think, the movement away from the comply or explain or COREX model, or CSR 2.0. Over to you, Sharad.
Yeah, thank you, Paco. As you all know, India was the first country to introduce CSR as a mandatory requirement. And at the same time, I think the fundamental concept of the boards of directors being trustees in whom the stakeholders repose complete confidence in their ability and integrity. Uh, and they need to really display that. There are three ways in which they actually intend to display that. One is very transparent and accurate accounting, disclosures and reporting, and internal and external checks and balances, whereby it can be transparently understood by all the stakeholders. So one of the paradigm shifts that's really happened, it took many companies by surprise, since it was announced suddenly on 22nd of January 2021. But what the rules have essentially done is that it has moved away from comply or explain, which means the basic model was that any company which has a requirement of which has a net worth of rupees 500 crore or a turnover of 1000 crore rupees or a net profit of 5 crores, all these companies are required to spend 2% of their average net profits computed over previous 3 years for corporate social responsibility. So once this spend requirement was there, and if the companies were not able to spend, the directors were required to really explain why the companies could not spend this on social responsibility. Why this is a paradigm shift is because the companies are now required to not just explain, but really can suffer penal consequences. However, the penal consequences, I must caution, are not that draconian, because the law also provides for certain things that companies can do to ensure that they are not penalized. So what are the key changes? First and foremost, every company must relook at their CSR policies. These must be more directional and not just list of CSR projects that the companies are going to adopt. These policies are supposed to issue directions and guidance as to how CSR projects will be picked up and what will be selected and how the budgets can be allocated. Uh, the activities of CSR, so there are two models in which CSR activities can be carried out. One by the company itself, so you can set up your own vertical undertaking CSR, or you could do it through another non-profit. It can be a company, it can be a registered trust, it can be a society. Now the new changes that are really required to be focused from 1st April is that there is a new registration requirement to ensure that these NGOs, these non-government organizations, are really recognized or are eligible. There is a new registration and a unique registration number will be issued to each of these NGOs. They need to be in CSR activities for a period of 3 years. And talking about the transparency, the actual utilization of CSR funds needs to be more focused. It needs to be monitored, and the chief financial officer or anybody who is in finance department heading that needs to certify to the board of directors, and board in turn will be able to report that to the stakeholders. Uh, what happens if the company is not able to spend the CSR budget? Number one, you can choose a project which is ongoing, which is like a multi-year, and you can commit some of the funds, unspent funds, to the earmark projects. And if you have these unspent CSR on ongoing projects, then you can transfer it to another escrow account of the company, and then you are able to utilize them over a period of 3 years. Number two, if you are still not able to spend that, you do not have any ongoing project, then there are specialized funds which are being used under Schedule 7 to the Act, to which the funds can be transferred. Now, the penal provisions that you really see at the last column, they will arise only if you are neither able to utilize the funds for ongoing projects, nor are you able to spend it during the financial year. So these are the some of the critical changes that have happened. One other change, which is more relevant for larger companies, where the projects are larger than rupees 1 crore and the companies are really spending significantly large amounts, these will be required to undertake impact assessment as well after the projects are complete. Thank you very much. Over to you, Paku.
Sure. Thank you so much for that timely update on CSR. Ladies and gentlemen, we have some questions coming in. So as Jay has indicated from the USIBC, please use the chat function to get those questions, and we will address them in the last 10 minutes of the program. So now we're coming to a section. I think the New York Times motto is all the news that is fit to print. However, we're going to adopt Rolling Stone's all the news that fits. And these are basically news items that might not have caught your attention, but we think that they're important anyway. We're not going to spend as much time on them, but my partners, Anushka Sharda in New Delhi and Atish, who you've met just a few minutes ago, who spoke about patents, please walk us through these developments in the next few minutes, please.
Thank you, Paku. Good morning, everyone. So I'm going to give you a bird's eye view of the recent challenges to the IT rules 2021 notified by the government earlier this year. Now, to say the very least, the information technology rules have created a significant stir in the industry. While it was always expected that these rules will govern intermediaries, the application of these rules to OTTs and digital news media as well has taken everyone by surprise. Now, considering the broad ambit of the rules, its validity has been challenged by various stakeholders, including users of social media, law reporters, OTTs, and journalists before various state high courts across the country. In fact, the Kerala High Court has even gone ahead and passed an interim order of protection from any coercive action being taken against the petitioner who approached the Kerala High Court. Now, in a more significant development, as recent as yesterday, Supreme Court has actually ordered these to be consolidated before the Supreme Court to avoid any conflicting decisions being passed on the same issue by different high courts. Just to give you a flavor, the touchstone on which Supreme Court is expected to decide the challenges include whether the IT rules exceed the scope of authority granted under the Parent Act to the government to frame delegated legislation. Do the rules violate fundamental right of privacy of users of social media in as much as they require intermediaries to share originator information, notwithstanding end-to-end encryptions, which many social media intermediaries claim to have? And lastly, do the rules violate separation of powers between the government and the judiciary in as much as they require the executive to sit in judgment over content on OTTs and social media intermediaries? Now, the Supreme Court is expected to hear these issues in the second week of April. That should give us more clarity on the validity of these rules and the compliance required by the various stakeholders. Thank you.
Regarding the next update, that is on the proposed IPAB abolishment, around 2015, the Government of India started the process of rationalizing all the existing tribunals, and by way of a Finance Act 2017, the government abolished or merged 7 tribunals with the existing tribunals, which led to the number of tribunals reduced from 26 to 19. One of such a tribunal was the Copyright Board, which merged with the IPAB. To further streamline the existing tribunals, the government has recently proposed the Tribunal Reforms Bill 2021 to abolish 5 more tribunals, which includes the Intellectual Property Appellate Board. By way of a background, IPAB was constituted on the 15th of September 2003 to hear appeals against the decisions from the Trademark Act, Geographical Indications Act, and then it was later extended to the Patents Act and then to the Copyright Act. The bill provides a mechanism to basically file the appeals directly to the courts from these IP offices. If we see the statements and objects of the bill, it states that the tribunals that were proposed to be abolished are of the kind which handle cases in which the public at large is not a litigant, or those which neither take away any significant workload from the high courts nor provide any speedy disposal. This is more because the cases do not achieve finality at the tribunal level and are litigated further till the high courts and the Supreme Courts, thereby increasing one level of litigation. For instance, while the decision of the IPAB can't be appealed, writs are being filed with the high courts and then it is taken to the Supreme Court. Well, while the requirement of the abolishment of IPAB is still being debated, according to me, if it leads to establishment of special IP courts, as was envisaged in the 2016 National IPR policy, then it's a welcome move. However, if there is no such proposed scheme, then it is just going to add burden on the courts, because the courts would be required to adjudicate on the appeals coming from the IP offices, revocation of patents, rectifications of trademarks, royalty determination under the Copyright Act, etc. The next update is on the Copyright Amendment. The intention of the Copyright Amendment Act and the rules are basically to bring the copyright law into line with all the other relevant laws and to ensure that it is in step with the technological advances of the current digital age. Some of the key amendments that are there is to expand the scope of broadcast under the Copyright Act to include the internet broadcast. Now, in one of the Bombay High Court case, that is in Tips versus Wink, this issue arose as the present act only contemplates royalties in relation to radio broadcasting and television broadcasting. The next key amendment that is being proposed are on the copyright societies. It is envisaged that we include the transparency in the functioning of the copyright societies, the mechanism to pay the author or the owner if he's unknown, annual transparency reports to be published regarding the licenses granted, denied, what are the tariffs that are being approached. Thank you. Thank you, Babu.
So thank you very much, Adish and Anushka. And now let's get on to our last two main stories. And this one, I think, has widespread influence for, speaking of the word influence, influencers of social media. And I think this applies to essentially any company that has a significant presence in social media in India. So my partner, Tanu Banerjee from Mumbai, she'll walk us through this. Over to you, Tanu.
Thanks, Baku. I think the increasing popularity of influencers amongst consumers of social media platforms, led to brands and advertisers increasingly engaging them for promoting their products and services on social media in introducing the influencer guidelines. The fundamental premise on which the guidelines basically the guidelines seek to monitor the influencer endorsements on digital media platforms and their activities. The basic premise being that a consumer should be able to distinguish between an advertisement which is done as a paid promotion versus a regular social media post. And to enable this distinction for the consumers, the guidelines provide that influencers should include a disclosure in their posts wherever they are doing a paid promotion. And further on, it sort of goes on to detail the kind of labels that the influencers should use, the placing in which the disclosures need to be done depending on the kind of the post it is and depending on the platform that the post is being posted on. Another important thing that the guidelines also provide is that they require the influencers themselves to do a certain amount of due diligence on the products and services that they are promoting. I think the way forward here would be that the different participants in this ecosystem, being the influencers themselves, the brands who are engaging these influencers, and also the platforms who are acting as intermediaries and do not as such have active control on the content that's being posted, to ensure that there is, to push towards adoption of these guidelines by influencers, so as to overall ensure that consumers are protected from misleading advertisement, and there is better transparency and accountability on the activities of social media influencers for the consumers. That will be it for me. Thank you.
Thank you very much, Tanu. And we're going to get to our last feature for today and then get into the Q&A, because we have actually quite a few questions that we already had and then many coming in. So I'm going to turn it over to our direct tax partner, Indruj Rai, who's in New Delhi, to talk about intermediary liability guidelines, which has gotten a lot of headline coverage in India. However, there's some unintended, perhaps intended consequences that you might not be aware of. And so over to you, Indruj, to tell our audience what might be hidden behind all of this.
Thank you, Paku, and good morning to everyone. Well, I'll really look to cover the tax consequences of the changes that were made to information technology rules. I understand there's been a special session on the changes to the information technology rules, so I will not get into detail, but largely the relevant changes that we will talk about and the consequences are regarding social media intermediary entities. Social media intermediary entities that have more than 5 million registered users in India have been asked by these rules to place 3 employees in India, namely a chief compliance officer, a nodal contact person, and a resident grievance officer. Now, what needs to be looked at from a tax perspective is if presence of these three employees will result in a taxable presence of a foreign entity which otherwise does not have any presence in India. A taxable presence of a foreign entity in India is referred to as a permanent establishment. Where a foreign entity is treated to have a permanent establishment in India, its global profits, to the extent attributable to work done in India, can be subject to tax in India. The rate of tax can be about 40 to 43%. Therefore, it's very important to analyze whether the forced presence of these employees by virtue of the rules can result in any tax leakage for the foreign entity. The analysis really determines and revolves around the exact role played by these individuals. Now, the rules require the chief compliance officer to be a senior level employee or to be a key manager personnel. So really the question will be, does he play a role which is as important and can said to be the core business of the entity, or can the role said to be only ancillary and auxiliary and support? Seems it needs to be debated and deliberated upon during the analysis, given that it would be a senior level employee. So one thing that one will look at is the employment contract and what role is charted out there, and in addition to also look at what is actually done on ground factually. Where there is a permanent establishment, there are certain mitigants that can still be considered, and it's not that it's all lost. Things such as that the employees must be remunerated on an arm's length basis, on an independent basis. In addition to the analysis on permanent establishment, what also needs to be considered by the foreign entity is when they are making payment of salary to the employees based in India, they would have an obligation to withhold tax. To be able to withhold such taxes, they will have to register themselves with the Indian tax authorities with a PAN and TAN, and also carry out certain tax compliances such as filing withholding tax returns, etc. For whatever reason, if the foreign entities has limited number of employees and does not wish to get a PAN and TAN, it can consider certain alternate options to mitigate its withholding tax obligations, such as where the employees themselves decide to pay tax on an advance basis on a monthly basis, but that may be a little too cumbersome. So this is the overall sort of synopsis of the tax issues that one needs to consider. Happy to address any more in detail during the Q&A. Thank you. Back to you, Paku.
Great. So we're moving into the Q&A portion. If any members want to speak, now would be a good time to raise your hand. I saw Gary, you had a question. Would you like to come on screen and share that?
No,
Gary
actually, that was just a mistake. Sorry.
No worries, no worries. So I do have a couple of background questions. There's a lot of the questions here are about penalties, and what does non-compliance mean in terms of penalties? So maybe in terms of the speakers, we could start in order and start talking about the software royalties, right? So sorry, I'm going to start with the new patent rules. Are there penalties for non-compliance with Form 27? And then with CSR, are there any penalties for non-compliance? And then as we go into the ASCI draft regulations, are there any penalties for non-compliance?
Yeah. So I'll take the first one, considering that it was in relation to the patent rules. So in case of non-filing of the working statement, there is a penalty of Indian rupees 10 lakhs, which would be approximately say 13,000 US dollars, which may be imposed. And in case of any false information which is furnished, then there can be a penalty which is basically fine or imprisonment up to 6 months.
Okay, great. And then what about on the CSR side, non-compliance? Are there any penalties there? How does all that work?
Sure. So primarily the obligations in CSR which are resulting in penalty, there are two very distinct types. One is more on spend, and really the emphasis is that the companies must spend in a very time-bound manner. So if the companies are neither able to spend or able to transfer it to the Schedule 7 funds well in time, then that is where the companies will really suffer financial penalties. They are as high as twice the unspent amount or rupees 1 crore, whichever is less. And every officer in default, of course, will get into a higher penalty. But if you really look at other procedural non-compliances, like if you have some lacuna in a policy, you are not able to furnish a utilization certificate. So those are more procedural, which are not really compelled with any significantly large penalty. First offense would be like 10,000 rupees, and continuing contravention could be 50,000 rupees. But these can be mitigated, but by just instilling more financial discipline.
Great. And Tanu, for you, non-compliance with the influencer guidelines, what's the implication there?
Right, hi Jay. So it's an interesting one, this one. These guidelines are basically notified by ASCI, which is a self-regulatory organization in India, and it's an autonomous body that sort of governs the advertising space. What ASCI by itself can do is recommend modifications or pull down of advertisements whenever there is a complaint that is raised, and it has its entire complaint redressal mechanism built into the body and the system. So therefore, just within the guidelines, perhaps there are no penalties. But what is interesting is that we also have a consumer protection legislation which is based on similar principles. And it also lays down penalties for misleading advertisers, which could be imposed not only on advertisers or brands, but also on endorsers, in this case, influencers. The penalties there could be in the range of 10 lakhs to 50 lakhs almost, and I think just compliance with these guidelines and the framework that ASCI has laid out would help in reducing exposure under the consumer protection legislations.
Great, thank you. So we have a question from the audience from Padma. I'm not sure if you want to come on visual. You're welcome to. If not, I'm happy to read the question. But it's about the CSR amendment. What type of can you clarify a little bit about expenses? What could be included under the administrative overheads? What about implementation costs that NGO partners charge and things of that nature?
So the administrative overheads, Jay, are essentially to ensure that you have a working department, CSR department, which will be more administrative and monitoring kind of a function. You can also have similar expense incurred by any organization, which is your implementation agency. Now, the limitation is that out of 100% of the CSR expense, the companies are only permitted to claim 5% of these administrative expenses towards CSR spend. So while the actual expenses could be higher, what they will get a credit for as a CSR compliance is only to the extent of 5%.
Great, thank you. We have a question for Adish, and it has to do with the intermediary guidelines. There's been a lot of discussion about how enterprise companies and cloud providers fall in. Can you discuss a little bit about how they are impacted and how they are not?
Yeah, Supratim.
Yes, sorry, I think
I think the question is to Supratim or to, yeah, please.
Yes. Oh, my apologies.
Yeah, no problem. So yes, I think there's a bit of a quick Q&A which is happening on the implication of this particular set of intermediary rules on the larger ecosystem, apart from, of course, social media intermediary and significant social media intermediary. One aspect, if you remember, Jay, we were in the rapid readout round, and it came out that when we are talking about social media intermediary, the definition is stating that an intermediary which primarily or solely enables online interaction. So a determining factor there could be that are we really primarily or solely enabling such an interaction? Therefore, all these set of requirements really fall on us. I think, to my mind, large number of players would get out of this bucket if they are able to prove that they are not qualifying for this bucket. As of now, that's the bit of analysis that we have done.
Great, thank you. So my final question goes off to our leadoff story, and of course, if any member or participant wants to raise their hand or ask more, we're happy to take a few more questions. But I know this software case was a very long time in coming. Can you elaborate on some practical applications of how the ruling actually impacts the supply chain and impacts companies?
Yeah, sure. So I think, what is most important, in any of these software contracts is not only the, I would say labeling of the contracts, but also the manner in which it is worded. One very important point, I would say, from a practical perspective is really to ensure that, the wordings of the contract make it absolutely clear that there is no intellectual property being licensed or allowed to be used in this particular contract. And that is where we've generally seen, the tax authorities really looking at that and, not looking at taxing it as a royalty. Also very important to note is that in many cases, where you have a tax treaty available to the software supplier, it is always good to take the protection under the tax treaty. For the simple reason that the definition of royalty under the Indian tax laws is way wider than that under the tax treaty. As a result of which, many a times the taxpayer or the software supplier would get the protection under the tax treaty and not be subjected to tax in India. Of course, very important to note from a practical perspective that India has introduced the anti-abuse provisions ever since 2017, and hence it is absolutely important that any entity which is looking to take the benefits of a tax treaty has commercial substance and justification and is not merely a dummy entity set up for tax planning. I would say that's the practical aspect of looking at any software contract.
Wonderful, thank you. So one last call, any hands raised or questions in the box? Going once, going twice, sold as they say. I really want to thank Paku and Aloy and the whole KCO group for putting this on. The idea was to quickly go through a number of issues that often get missed in the kind of excitement of our day-to-day activity. I found this really interesting and I learned a lot. I hope our members did as well. I'd be curious for some feedback and future topics to be included as well. With that, Paku, I want, if you could come on screen, I'd like to just give you a thank you for organizing this and moderating a really great conversation. And let me also thank all of the KCO lawyers that spent time developing those slides. We will make those slides available. And of course, if anybody has direct questions, do please feel free to reach out to our colleagues directly. And with that, I guess this is the end of our first edition of our nightly news digital economy roundup. And I look forward to future iterations and hope you will tune in to those as well. So thank you and have a good night.
Thanks, everybody.